The first speaker this morning, if you will refer to your schedules, is Mr. Morris Manning, Queen's Counsel. Horace was called to the bar in Ontario in 1967, appointed Queen's Counsel in 1979. Those of you who are from Toronto know that Mr. Manning practices in Toronto in all of the civil and criminal courts in the province, and in addition to carrying on a busy practice, he has lectured extensively and written legal texts in the fields of criminal law, administrative law, and advocacy. He's the author of Advocacy in the Supreme Court of Canada, author of the Protection of Privacy Act, Analysis and Commentary, author of Wiretap Law in Canada, and Rights, Freedoms, and the Courts, which is a practical analysis of the Constitution Act 1982. And co-author of the Canadian Text Criminal Law. We're very fortunate to have him with us this morning, Mr. Morris Manning.
I was told by Bernie McGarva that they're going to try and get coffee to you by the break. How long are you going to be? He said, and I said 10 minutes if it means getting coffee. Unfortunately, the subject matter is a bit dry. We'll try and loosen it up a bit. Anyone looking at this area of tort liability for breach of statute must necessarily start by reading Mr. Justice Linden's text, Chapter 7, Canadian Tort Law, dealing with this subject. In that particular chapter, His Lordship analyzes the English and some American positions and cases and Canadian cases. And one must also look at a case called Johnson versus the Attorney General of Canada. I was just speaking a moment to Rosalind Levine, who argued that for the Attorney General of Canada and argued it quite well. She said that, well, that's now been laid to rest by the judgment in the Saskatchewan wheat pool case. I spoke to Mr. Justice Linden 2 days ago, and he said, well, that takes care of about 70 pages of my book. Now all we have to do is analyze the Saskatchewan wheat pool case, and there's the end of the case. There's the end of that chapter. I'm not convinced. I suppose that happens when you're a little more experienced than Rosalind and are in practice as opposed to being a judge. You look at a judgment of the Supreme Court of Canada to say, where does it lead me? And now what, if anything, can I do with it? Hopefully I can assist you with respect to that. The Saskatchewan wheat pool case, the title is Her Majesty the Queen and Right of Canada versus Saskatchewan wheat pool, was a decision released on February the 8th of this year, a unanimous judgment of the Supreme Court of Canada, and interestingly enough, a judgment written by Mr. Justice Dixon. I say interestingly enough because at the end of the chapter, it's almost as if Mr. Justice Linden and Mr. Justice Dixon got together. Mr. Justice Dixon's judgment in the Manitoba Court of Appeal in School Division of Assiniboine South versus Hoffer and Greater Winnipeg Gas Company is the last case referred to in the chapter in dealing with the tort liability for breach of statute. And in that judgment, Mr. Justice Dixon, as he then was, speaking for the Manitoba Court of Appeal, said evidence of compliance or non-compliance with a statutory rule undoubtedly has a decided bearing on civil recovery. I would not wish, however, to rest a finding of negligence or, as it is often termed, statutory negligence against the gas company upon breach by it of the Public Utility Board regulation. So there, the die was cast. It was cast in other cases, but nothing was done definitively until the recent judgment of the Supreme Court of Canada. The topic that I'm going to deal with today, and the time allotted and subsequently in the written material, it is expanded. We can't cover it all today. We'll deal with a slightly different aspect of tort liability arising from statute than is discussed in Mr. Justice Linden's text, or even in the decisions of Johnson, which is a judgment of Mr. Justice Linden last year, and in the case of the Saskatchewan wheat pool. I'm going to look at the background of the Saskatchewan wheat pool case and the holding in that case in order to give you a background or a backdrop against which you can then look at breaches of statutes as assisting you in your practice. When I say assisting, the controversy between the two positions, one whether the breach of a statute gives rise to a nominate tort or a cause of action per se, as opposed to the other position, whether it is merely evidence of negligence, is now laid to rest to a considerable degree. Well, no, that part of it's laid to rest by the Supreme Court of Canada. The Supreme Court held, quite simply, that a breach of a statute does not per se create a cause of action. It does not also per se equal negligence. It may be some evidence of negligence, and that's as far as the breach of the statute goes. In other words, the statute is looked upon as setting a standard of care. And if there's a breach of the statute, that may be some evidence to assist you in a negligence suit. But importantly, you must plead negligence and you must prove negligence. What happened in the Saskatchewan wheat pool case was that they pleaded breach of the statute alone. They did not plead negligence, and they lost the case because the court said breach of a statute by itself doesn't give rise to a cause of action. During my discussion of the wheat pool case, and I'm going to spend some time on it because it is important, I would ask you to keep in mind the hypothetical situation that might arise in a case where you're contemplating breach of the Constitution as giving rise to a cause of action or as evidence of negligence. Keep in mind the kinds of situations that were discussed yesterday, certainly in the invasion of privacy field, where a person's privacy is invaded intentionally or negligently. The question can arise, not only can the courts look upon that type of action as giving rise to a cause of action, but what kind of cause of action? Well, breach of a constitutional right as a cause of action or as evidence of negligence is part of the subject that I'm going to deal with today. The facts in the wheat pool case are really quite simple, although as an Easterner, I found it very interesting to learn that the amount of grain shipped from Saskatchewan to Thunder Bay, Ontario, varies from 100 railway carloads a day to 600 or 700 carloads a day, depending on the time of year. The wheat pool was a grain dealer operating a grain elevator in Saskatchewan. It had a handling agreement between itself and the Canadian Wheat Board in respect of grain elevators operated in other parts of the country, especially in Thunder Bay, where the wheat was received from Western Canada. The wheat pool agreed to act as an agent of the Canada Wheat Board to accept delivery of and to carry out the purchase of grain. The board was an agent of the Crown, and that should be kept in mind because part of what I'm also going to deal with, certainly in the written materials, if we don't have time today, this morning, is the liability of the Crown now looked at afresh because of the Constitution, because the Constitution now sets, in my view, certain standards that the Crown has to the Crown is bound by. The board was an agent of the Crown and was authorized under the Act to buy, sell, and market grains grown in Western Canada for marketing in interprovincial and export trade. In designated areas, the board is obliged to buy all the wheat produced and offered for sale and delivery. The grain is placed in storage at a primary elevator and is not required to be stored separately from grains from other elevators. At the request of the board, wheat of the same grade and quantity is shipped by the pool and other elevator companies from the primary elevators to the terminal elevators of the pool and other licensed elevators. As the carloads of grain arrive at the terminal elevators, samples are taken by inspectors employed by the Canadian Grain Commission. The samples are visually scrutinized to see whether there has been an infestation of insects. But the tests are performed on only about 10% of the grain entering the terminal elevator. The testing is done at the headquarters office of the Grain Commission in Thunder Bay, but the results are not known for 2 or 3 days, by which time the grain is either all in the elevator mixed with other grain or is on a ship bound for other countries. When the grain arrives at the terminal elevator, it's weighed, graded, binned, all under the supervision of the Commission. A terminal receipt is then given to the primary elevator operator. The dispute arose from the finding of an infestation in the grain of rusty grain beetle larvae, and it's sufficient to say that when the wheat was loaded, it was done under the scrutiny of the Commission's inspectors as well as the scrutiny of the pool's representatives. No one at the time of the loading had any knowledge of the infestation. It was only after the grain was on a ship, which was bound for another country, that they discovered the larvae. The Canadian Grain Commission ordered the board to fumigate the affected wheat. The ship was radioed, diverted its course to Kingston, where it dumped the grain, fumigated the hold, and the board was then obliged to pay about $100,000 for detention claims, cost of unloading and reloading the grain. They apparently cleaned it out, and the fumigation of the grain in the holds. The board turned around and claimed that amount from the Saskatchewan wheat pool. And of vital importance to the case, as I mentioned a few minutes ago, was the fact that the plaintiff made no claim in negligence in the suit. They claimed strictly on breach of statute. At the trial, Mr. Justice Collier in the federal trial court gave judgment in favor of the board, and he held that since the Canada Grain Act prohibited the delivery of infested grain out of a grain elevator, that constituted a duty on the defendants which could be enforced by the persons that were injured by reason of the breach of the duty. It was a statutory duty which he held to be absolute, and evidence of reasonable care was not sufficient to absolve the pool of liability. The case then went to the Federal Court of Appeal, which reversed, that court finding that the Canada Grain Act was there to regulate the grain industry and to protect the public. It was legislation imposing general duties and obligations, but the board could not rely on a breach of the statute in order to found a civil cause of action, nor was there an absolute duty upon the operators of the elevators. The court held that the Canada Grain Act did not grant a private right of action to persons who suffer loss from a breach of statutory duty imposed by the Act. The case then went to the Supreme Court of Canada, and that court dealt with two issues, one of which need not concern us. The other was the main issue of whether a breach of the Act by the delivering of grain which was infested with this larvae conferred upon the board a civil right of action against the pool for damages. The court was faced with what it called uncertainty and confusion in the relation between breach of statute and a civil cause of action for damages arising from that breach. Of course, the term confusion was the same term used by Mr. Justice Linden in the Johnson case, and indeed is referred to in his text. Referring to the law in the United States and England as, quote, two very different forces, quote, Mr. Justice Dixon, in a careful analysis, reviewed the position of the law in both countries. In the United States, The civil consequences of breach of statute was held to be subsumed in the general law of negligence. While in England, in the words of Mr. Justice Dixon, we have witnessed the painful emergence of a new nominate tort of statutory breach. Painful because the cases attempt to seek a justification in some instances for holding that there is a tort, and in other instances for holding there isn't. They all looked for what the court called the will o' the wisp. They looked for the intent in the statute to create a cause of action, where the statute itself said nothing about creating a cause of action. The court had a policy decision to make. It looked upon its previous decision in Sterling Trust Corporation, where it was called upon to make the same policy call. It said in the Sterling Trust case, we're not going to get into that right now, we don't have to. In the Saskatchewan Wheat Pool case, they said, it's imperative that we now make that determination. And they made that determination, and they chose what they referred to as the minority American decisions. The English decisions saying it was a nominate tort by itself was rejected, that is breach of a statute. The American decision saying it's negligence per se was rejected, and they opted out for the middle Canadian ground, saying it's evidence of negligence. It's not negligence per se, but it can be evidence of negligence. The judgment of Mr. Justice Dixon quite clearly shows that the court wanted to create a rule which was flexible enough to deal with a breach of an administrative or penal type statute as well as civil statutes. In this way, the court felt that a defendant in a civil case should also be able to benefit from technical defenses or protection offered by the criminal law. And there's a great deal of emphasis on criminal law, both in this judgment and in Mr. Justice Linden's text, on the basis that civil consequences might easily outweigh any penal consequences attached to breach of the statute. Interesting comment. You know, you can go to jail, and that's not as bad as being hit with a large fine. I have a lot of trouble with that. He adopted the approach as being consistent with the compensatory aspect of tort liability, it having won over the deterrent and punitive aspect. The judgment is not only important for this topic, but for the general law of torts, because there's a number of policy statements in that judgment which deal with the Supreme Court of Canada's view of the law of torts, and that's one of them. I'll repeat that. He adopted that approach because he felt it was consistent with the compensatory aspect of tort liability, which he views as having won out in the long common law battle over the deterrent and punitive aspect. The evolution of the use of civil liability as a mechanism of loss shifting to that of loss distribution. In reaching the conclusion whereby the court rejected recognizing the nominate tort of statutory breach, the court states that the tendency of the law of recent times is to ameliorate the rigors of absolute rules and absolute duty in the sense indicated, which is contrary, they say, to natural justice. Query then, what happens to strict liability situations? Is the court really saying that if you have a strict liability situation in any branch of the law of tort, or in criminal law for that matter, that's contrary to natural justice? I'll leave that for your consideration. In dealing with the facts of the case, the court noted that while Parliament could provide, constitutionally that is, for a civil action where a person is injured by a breach of the Act, the Canada Grain Act did not do so. Attempting to be true to the principles espoused, the court does not search for parliamentary intention to create a private cause of action. Instead, it looks to the pleadings and the way in which the case was presented. Since the board proceeded as if a breach of the Act gave rise to an independent cause of action or an independent tort, and since negligence itself was not pleaded, the case was dismissed. In other words, the board had failed to prove at trial either an intentional or negligent failure to comply with a statutory duty which statutory duty was looked upon as setting a standard of conduct. Indeed, it had been shown that the pool operated its terminals up to the accepted standards of the trade and had successfully demonstrated that the loss was not the result of any negligence on its part. These are the following 5 points set out at the conclusion of the judgment in as lucid a way as any of the other judgments that Mr. Justice Dixon writes. First, civil consequences of breach of statute should be subsumed in the law of negligence. Second, the notion of a nominate tort of statutory breach giving a right to recovery merely on proof of breach and damages should be rejected, as should the view that unexcused breach constitutes negligence per se, giving rise to absolute liability. That's the approach first of the English, second, the majority American view. Third, proof of statutory breach, causative of damage, may be evidence of negligence. I'll deal with that in a moment. Fourth, the statutory formulation of the duty may afford a specific and useful standard of reasonable conduct. And fifth, in the case at bar, negligence is neither pleaded nor proven. The action must fail. What then is the result? The court has held that if you're going to rely on a breach of a statute, you have to plead negligence and you have to show a breach of a statutory duty. It seems you must also show that that breach causing damage may be evidence of negligence. Simply put, you must plead and prove negligence. And what then of the statute? Since the statute breach may be a falling below a standard of reasonable conduct, the breach itself may afford a specific and useful standard of reasonable conduct. Wherever there is an intention to rely on a breach of statute as a tort per se, you forget about it. You can't do it anymore. Instead, you have to look to the statute and say to yourself, does the act create a standard of reasonable conduct? Has the defendant, by breaching the act, shown a falling below that reasonable standard? Is that, in other words, is that evidence of negligence? Of course, you're in a much better position if the statute itself creates a duty and puts a duty on certain people to do certain things. That is very clear. And probably the most important fact of the wheat pool case lies in the fact that the Canada Grain Act itself did not specify nor provide that anyone injured by a breach of that act could have a civil action or a remedy by civil action. This fact, coupled with the finding of the court that there could be civil consequences for breach of a statute, although subsumed in the law of negligence, means that even though a statute does not create a cause of action, by its very terms, that statute may still lead to a recovery of loss sustained by reason of the breach of the statute. So the question is, did the Saskatchewan wheat pool case really change a heck of a lot? Some people will say yes, others will say no. Here are some problems that I think may yet be unresolved. Does the rule, as set down in the Saskatchewan wheat pool case, apply only to penal and administrative statutes? Can one use the statute merely as a crystallization of the standard of care already owed under negligence law? Or can the court still create a civil duty and also set the standard of care required of those that the statute is aimed at protecting? Does one still have to be a member of a class that the enactment was designed to protect? Is there still a requirement that the damages resultant from the type of loss it was meant to prevent? In other words, does there have to be a proof that this statute was designed to protect certain individuals from certain kinds of damage, and that the damage actually sustained was within that umbrella? I leave you at this juncture with the Saskatchewan wheat pool case and the following comment from a previous case in Johnson versus the Attorney General of Canada by Mr. Justice Linden, where he said that in his conclusion as to the uncertainty in the area, this was prior to the Saskatchewan wheat pool case, that the trial court, that was a motion under Rule 126 to strike out the statement of claim as disclosing no reasonable cause of action. that the uncertainty in the area, because of the uncertainty in the area, he dismissed the application by the defendant and said that the trial court may well decide to employ the statutory provision in the Aeronautics Act in that case to particularize the standard of care issue in accordance with negligence law theory. And he said perhaps at that time some of the fog that pervades this area will be dissipated. You have to ask yourself, has it been completely dissipated or merely lifted? The next area and main area that I'm going to deal with, remembering that the Saskatchewan wheat pool case has now said that a breach of a statute per se does not give rise to a new nominative tort, but may show evidence of negligence which can be useful if you plead it, is the area of the Charter of Rights. And when one thinks of the rights and freedoms enshrined in the new Charter, in the Constitution field, certainly the field of criminal law springs to mind. One should be wary of limiting one's horizons because there certainly is a lot to be found in the Charter in the civil litigation field. I'm going to concentrate on the question of whether or not you can use the Constitution either as creating a cause of action, notwithstanding the Saskatchewan wheat pool case, this not being an ordinary statute, or as showing evidence of negligence and being useful in that way. There certainly has been very little dispute in the United States at the state level that a violation of a constitutional right by a person acting under color of state law may give rise to a cause of action and an award of damages. Many years ago, the United States Congress created a cause of action in respect of state law, and in 1976 they codified that cause of action in what's known as 42 U.S. Code Section 1983, not to be confused with the year 1983. The provision is important because it sets out an express grant of a cause of action, but that's at a state level. I'm going to discuss it as an example of an express grant of a cause of action arising out of a constitutional violation. And secondly, I'm going to deal with the United States Supreme Court decisions recognizing a comparable civil cause of action against federal officials as being implied in the federal Constitution. In other words, a situation substantially similar to that which could arise in Canada, except we're in a better position by reason of Section 24 of the Charter. The Section 1983 reads, "Every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory, subjects or causes to be subjected, any citizen of the United States or any other person within the jurisdiction thereof, to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress." In other words, at the state level, an explicit cause of action created for breach of constitutional rights. In 1971, the Supreme Court of the United States, in a case called Bivens versus 6 unknown named agents of Federal Bureau of Narcotics, great name, was invited to hold that violations of constitutional guarantees by federal officials may give rise to a cause of action in tort and may also give a remedy in damages under the Constitution. Now, always keep in mind, when dealing with the United States Supreme Court decisions in this area, that their Constitution and their amendments, the Bill of Rights, does not contain the specific section that ours does in Section 24. If the claim had been commenced under state law, the codified cause of action in Section 1983 of the U.S. Code would clearly have provided Bivens with a cause of action. But it was argued that since there was no federal counterpart, there was no cause of action. The court had to find that the existence of a cause of action, if one existed at all, was implicit in the Constitution itself. The issue had been raised in previous cases but left unresolved. In one case, in Bell v. Hood, the Supreme Court observed that the question was one that had never been specifically decided, that the complaint stated a claim which would arise under the Constitution or laws of the United States was acknowledged in Hood, but no decision was forthcoming on whether the complaint alleged raised a cause of action as pleaded. On a remand to the district court, the suit was dismissed on the basis that the complaint did not state a claim for which relief could be granted. A further hurdle to be jumped over in the Bivens claim was the previous opinion in the Supreme Court of the United States in Linden v. Wheeler, where the court in obiter expressed doubt concerning a constitutional claim for damages. Although the issues in Bivens were complex, the facts are rather brief, and they can be outlined in summary fashion as follows. Bivens, as a petitioner, claimed that the agents of the Federal Bureau of Narcotics, acting by virtue of federal authority, entered and searched his apartment without a warrant and arrested him on narcotics violations. Pausing there, refer back to yesterday's lecture by Professor Irvine in the privacy field, his comment that privacy interest may be protected under Section 7 of the Charter, the phrase security of the person, and continue reading Bivens. They manacled Bivens in front of his family, took him to the federal courthouse where, among other things, he was interrogated and subjected to a visual strip search. The suit in the federal district court claimed $15,000, so much for the large claims that one sees in negligence actions in the United States and certainly in California, from each of the federal agents for humiliation, embarrassment, and mental suffering. It's interesting to note that at the lower court levels there was a marked refusal to accept that a cause of action against federal officials was implied in the Constitution. The complaint was uniformly dismissed on the basis that it failed to state a cause of action. On a certiorari application, the Supreme Court of the United States reversed the Court of Appeals for the Second Circuit. Mr. Justice Brennan held that a cause of action against federal officials for a violation of constitutional rights was implicit in the Constitution. In rendering the opinion of the court, the learned justice turned the table, so to speak, if I can put it that way, and emphasized that there was no explicit congressional declaration that persons injured by a federal officer's violation of the Fourth Amendment may not recover money damages from the agents. In other words, he didn't say that because there's no explicit cause of action, you don't have a cause of action. He says because there's nothing to prohibit it, you have one. And that approach is to be contrasted with the lower court decisions and the previous decisions of the Supreme Court of the United States. The definition and analysis by Mr. Justice Brennan is instructive and may prove to be of relevance in attempts to base a cause of action in tort on a breach of the Charter of Rights. In response to the government's submission that a more stringent test is required to govern the granting of damages in constitutional cases because such a concession is the prerogative of Congress, and pausing there as an aside, many of you do know that certainly the law in England for some time has been that for breach of constitutional rights, not only is there a cause of action, but you can be given punitive damages. Mr. Justice Harlan said in his separate concurring judgment, to be sure, it must be remembered that legislatures are ultimate guardians of the liberties and welfare of the people in quite as great a degree as the courts. But it must also be recognized that the Bill of Rights is particularly intended to vindicate the interests of the individual in the face of the popular will as expressed in legislative majorities. At the very least, it strikes me no more appropriate to await express congressional authorization of traditional judicial relief with regard to these legal interests than with respect to interests protected by federal statutes. The issue then, as defined by the court, was whether some form of compensation is necessary or appropriate. Consider those two words in relation to the words used in Section 24 of the Charter of Rights. To the vindication of the interest asserted. I repeat that. whether some form of compensation is necessary or appropriate to the vindication of the interest asserted. More important, especially in light of the Charter, was the acknowledgement that the court, in addressing the issue, should have regard to the same policy considerations that the legislature would bear in mind in deciding on appropriateness of legislating a remedy for violations of constitutional rights. Now, many of the comments in that judgment are restricted to violations of specific constitutional rights, which involve an element of deterrence of improper police conduct. The court dispelled any illusion that compensatory relief for an aggrieved party must be contingent on his ability to demonstrate that future official lawlessness will be deterred by an award of damages. That may be, says the court, the underlying rationale behind the exclusionary rule of evidence. It's not the rule in tort law for breach of constitutional rights. And certainly that's even more appropriate with respect to our charter, because our charter, certainly the exclusionary evidence rule in section 24.2, is also not based on trying to control the police, but trying to preserve the integrity of the administration of justice. I would suggest, with respect to those who hold a contrary view, that the approach in Bivens is a sound one and is worthy of application in tort actions found in the Charter. It will be recalled that Bivens dealt with violation of the Fourth Amendment to the American Constitution, and as all federal causes of action must be implied in the Constitution, the scope of the decision is not really clear. In a further case called Butts versus Economou, it was suggested that Bivens established that compensable injury to a constitutionally protected interest could be vindicated by a suit for damages invoking the general federal question jurisdiction of the federal courts. And although it was pointed out that the court's opinion dealt only with the Fourth Amendment violation, the language used would seem broad enough to contemplate a cause of action for any constitutional violation. Bivens has been described in a number of lower court decisions in the United States as a federal counterpart to the Section 1983 action, which of course it is. And if one surveys the decisions, they suggest that Bivens will be accorded an expansive interpretation so as to imply a cause of action for a broad spectrum of constitutional violations. This by the judiciary, who prior to Bivens kept saying there's no cause of action. I see my time is running. In the written materials to be subsequently distributed, I've analyzed a number of subsequent decisions showing some of the problems that one might have in bringing this kind of tort action. It certainly is worth a try, particularly where an individual has suffered by reason of the acts of a government official. Whether the charter will be held to apply to private actions is certainly much more contentious. Actions by the officials acting under any of the regulatory statutes, both federal and provincial, may give rise to a cause of action or may give rise to evidence of negligence. And if damages are suffered, either general or specific damages, or punitive damages are sought, which does in itself create a problem, then I think it can be said that certainly, taking my concluding remarks from the title to this lecture series, the torts in the 80s certainly will be much more interesting than in the 70s. Thank you.